to obligations which are enforced or recognized by law. A contract in an agreement is either written or oral, and is one by which two or more parties having legal capacity agree with sufficient certainty in accordance with the terms and conditions that are expressed or implied to perform certain obligations, either for a benefit or a detriment, that are not contrary to law or public policy. The first requirement of a contract is that the parties should have reached an agreement. Generally speaking, an agreement is made when one party accepts an offer made by the other with the intention of creating legal relations. It is important to note that the law of contract differs from that of tort and criminal law. The distinction between tort and contract is that in tort, the duties of the parties are primarily fixed by law, whereas in contract they are fixed by the parties themselves. In other words, contractual obligations arise as a result of agreement between the parties, while tortious duties are created by law independently of the consent of the parties. There are areas where there is an overlap between the principles of tort and contract. Such areas include fraudulent misrepresentation in contract, which is almost the same as the tort of deceit. Negligent misrepresentation is a concept common to both the law of contract and the law of tort. Similarly, agency is recognized in both contract and tort, though they are not applied in quite the same way. One distinction between the law of contract and the law of tort is found in the aim of damages, as tort law is designed to protect the status quo. There are fundamental differences between criminal and contractual liability. The criminal law protects the interests of the public at large by punishing those found guilty of crime. A conviction for a crime is obtained through a criminal prosecution instituted by the state. A breach of contract is purely a civil wrong, however. It gives rise to civil proceedings intended not to punish the defendant but to compensate the claimant for the damage which he has suffered. An important distinction between an action for breach of contract and a prosecution for a crime is that in criminal prosecution the case must be proved beyond reasonable doubt, while in an action for breach of contract the claimant must prove his claim on a balance of probabilities. A lesser degree of proof is required in a civil case than in a criminal prosecution. As a result, it may be easier to prove the breach of contract than the crime. The whole purpose of the law of contract is to provide a remedy for parties to contracts when they have been damaged by the wrongful performance or non-performance of the other party. There are generally 10 remedies for breach of contract: compensatory damages, non-compensatory damages, specific performance, injunction, rescission, rectification, restitution, quantum Myriad, withholding performance, and termination. Compensatory damages aim to award the claimant the loss he has suffered as a result of the breach. In the case of Chaplin and Hicks, 1911, it was stated that the aim of damages in contract law is to put the claimant in the position that he would have been in had the contract been performed in accordance with its terms. The loss must have been reasonably foreseeable. The defendant's breach must have caused the loss. In the case of Hadley and Baxendale, the court held that the claimant would be able to recover such loss as would usually be the cause of the breach. The claimant does not have to bring such usual types of laws to the defendant's attention in order to recover in respect of them. In the case, law says that one would ordinarily expect someone to suffer as a result of the breach. Such loss is only recoverable if it was reasonably foreseeable to the defendant at the time the contract was made. Non-compensatory damages. An agreed price. A claim for an agreed price or the contract sum is a claim for payment of a debt, not a claim for damages. Liquidated damages. The parties may agree in advance while making their contract that the breach of their contract by one or both parties would result in a particular sum being payable to the other party. Specific performance. Specific performance is an equitable remedy. It is used to enforce the primary duty of the defendant to perform the contract. Equitable remedies are said to be discretionary. This means that the claimant is not automatically entitled to specific performance or an injunction just because he can show the defendant broke the contract. There are a number of factors that may cause a court to refuse the order for specific performance. One is where the common law remedy of damages is an adequate remedy. The court will only grant specific performance if damages will be an inadequate remedy. Injunction. An injunction is an equitable remedy whereby the court orders a party to do something or to refrain from doing something under the pain of imprisonment or fine for disobeying the injunction. Rescission. Rescission means to undo the contract. Rescission involves, so far as possible, restoring the parties to pre-contract positions or restoring the status quo. It means unraveling the contract ab initio, setting it back to the beginning. This may apply in cases where there has been a mistake in the contract, there has been misrepresentation, or there has been undue influence. Rectification. Rectification is the rewriting of a part of a written document where one or both parties are mistaken as to its terms. There are various conditions which must be satisfied before rectification for common mistake may be available. They include: A. The mistake must have been a mistake in recording the agreed terms in the document. B. The mistake must have been common to both parties. And C. There must have been a prior concluded agreement or common intention. Quantum Myriad. This expression means as much as he deserves. When a party claims to be entitled to a reasonable sum for the services he has provided, this claim is often called a quantum Myriad. Withholding performance. The law on whether a party to a contract may withhold performance is part until the other party has performed is complex. Generally, if the contract is so structured that one party has to perform some or all of his obligations, but the other party has to perform his obligations, then the second party will be entitled to withhold performance until the first party has performed. In termination, where one party fails to perform the contract without some lawful excuse, the injured party will have an action for damages. In addition, in some cases, he will be entitled to terminate the contract. We have seen that this can be done where the term is one classified by the court as a condition. Termination can sometimes be an attractive remedy as compared to damages.